Hello friends, I hope you all are doing well and staying safe at your own place. I, C.A. Pujin Kapadia, welcome you all on my today's lecture on the subject Mercantile Law. As you all are well aware, we had started the act named the Indian Contract Act 1872, under which we had covered various topics till date. Lastly, we had started with a new topic, the name of which was capacity or competence of parties, under which I had broadly explained you that we are going to study which all are the parties who are actually capable, who are actually competent enough to enter into a valid contract. So I had taken up the first slide, that is section 11, under which we had studied the parties should be competent to contract. That is, they should be having the following characteristics. First is they should be major. That is, their age should be 18 years or above. If a person is below 18 years, he will be considered as a minor and he is not capable to enter into a valid contract. So the first criteria is majority, which means his age should be of 18 years or above. Second is he should be of sound mind, which means he should not be mentally unstable. He should be having a rational thought process. Third point is not disqualified from contracting. That is, they should not be. I have added certain points which you are supposed to remember. He should not be disqualified, which means he should not be lunatic. Lunatic means he should not be mentally ill. He should be at least in a state of mind that he is able to make the rational decisions. Second is he should not be drunkard. Drunkard means he should not be totally alcoholic so that he is not in a pleasant state of mind to take any kind of decision. Third is he should not be insolvent. That you very well know what is insolvent. If your personal liabilities are exceeding your personal assets, then actually you are not having anything for which you will be liable to be enter into a contract, as a result of which again insolvency is a disqualification. Next is alien enemy. That is, if you are an alien enemy to a particular nation, you are not qualified to enter into a contract in our country. Next is convicts, that is imprisoned. Now say for example, Mr. X is imprisoned for certain crime for 5 years. Now during this 5 years of imprisonment, he will be termed as he is convicted, as a result of which for this 5 years he will be disqualified to enter into the contract. That is, he cannot make any contract for the term of his imprisonment. Once the imprisonment is completed, that is, he has duly complied with the punishment he was supposed to complete, then he can be again be qualified to enter into a contract. But for the period of conviction, for that particular period of imprisonment, he is disqualified to enter into the contract. The last point is any foreign sovereign. Foreign sovereign are basically the official persons of the another country. You can say the embassy, fine. That is, for example, there is an official embassy of USA who is having a place of business, or you can say who is having his office in India. So basically, he is here in India on behalf of USA. But what we say, the official embassy, the foreign sovereign. Now, such person, no contract can be enforced against him. So he may be the beneficiary to a contract, but we cannot enter into any contract which are against him. So again, this is the partial disqualification with respect to same. So friends, in short, you are supposed to remember that under section 11, the party should be competent or capable to enter into the contract. Now, what are the characteristics of the same? We have read in this particular slide. I hope I am clear with this particular topic. We had started the most important question from the viewpoint of your examination that I had already told you in a previous lecture also, that you need to do this particular question in such a manner that it is going to come definitely in your examination, because this is the most important question for your entire syllabus. As a result of which, the topic of which was provisions of the Indian Contract Act with respect to minor. So you may be asked as a question to discuss the provisions with respect to minor in the Indian Contract Act 1872. So basically there are many points that we need to take care of at the time of contracting with respect to minor. So let's discuss each and every provision in detail. The three we had already discussed. Primarily slide was telling who is a minor. Section 3 of Indian Majority Act 1875 said that generally in India it is said that if a person has completed the age of 18 years, he will be considered as a major. If not, he will be considered as a minor. But there were two exceptions that we had discussed. And in that particular exceptions, instead of 18 years, I need to remember the criteria of 21 years. That is, if I am not of the age of 21 years, I would be considered as a minor. So instead of 18, we are having the criteria of 21 under two exceptions. First was when the guardian for the minor is appointed by the court of law. So when law is appointing any person as a guardian, you can say as a caretaker of the particular minor, then in that particular case, the age of majority will increase from 18 years to 21 years. And the second scenario is when the minor's property is taken over by the court for management. Sometimes what the court passes an order is that the property of minor is taken over by the court itself for the purpose of management. So when this is the case, again the exception is going to hit, as a result of which the age of a majority is going to increase from 18 years to 21 years. So you are supposed to remember over here that as per section 3 of Indian Majority Act 1875, generally the age to attain majority is 18 years, but in case of two exceptions, it is 21 years. I hope I'm clear like who is minor. Fine. Okay. So we had started with the topic of the provisions. The first provision was minor's agreement is void ab initio, which means it is null and void from the very beginning, the time I am entering into the contract. So it is known as void ab initio, under which I had requested you all to learn the name of the case law of Mohori Bibi versus Dharmodas Ghosh of the year 1903. Under it, there was a thing where there was an immovable property in the name of minor. Minor has availed the mortgage amount and entered into an agreement that he is going to have rupees 20,000, out of which he has already received 8,000. Now minor sued that particular lender that he cannot have the mortgage on his property. Why? Because he was minor. As a result of which, in the court of law, it was held that this agreement was void ab initio. It was already null and void, as a result of which it was not having any kind of legal existence. So minor was not under any obligation to return the rupees 8,000 that he has taken from the lender. So this was the case. However, minor's parents and custodians shall not be liable for any dealings done by the minor without their consent or knowledge, which means if minor is doing anything, he is taking up any obligation, any liability, his parents or his guardians are not going to be held responsible for the same unless and until they are having the knowledge about the same. So if they are aware, if they have consented him to do something, then they could be held liable. But if they were not aware at all, then they cannot be held liable for the dealings of the minor. So this was the first topic, that was minor's agreement is considered as void ab initio. Next was minor can be promisee or beneficiary. We know that if any agreement is entered with the minor, it is void ab initio. It is null and void. However, agreement can be entered in such a manner where the minor is going to be the beneficiary. He is going to be benefited out of that particular agreement. So I have written in the third point that if I am drawing any promissory note in favor of minor, then it is valid. That is, if I am drawing an agreement, a negotiable instrument under which I am mentioning that I promise to pay that Mr. X, who is a minor, rupees 10,000 after 1 month. Now in this particular case, minor is going to be benefited by this particular agreement, as a result of which this agreement can be held valid. So you need to remember that yes, minor can be promissory or he can be the beneficiary. Next topic was no ratification. So first of all, I had explained you what is the meaning of ratification. It means the action of signing or giving formal consent to a contract or agreement and making it officially valid. So if we had entered or drafted certain agreement or contract, but still when it is going to become valid, whenever I am signing that particular contract or I am giving my formal consent, my formal permission to go ahead with that particular thing. So ratification means giving your consent to make your contract officially valid. Now I have written over here in the second point, a minor on attaining majority cannot ratify an agreement entered into while he was minor. So when any agreement was entered with minor when he was minor, on attaining majority, he cannot give official validity to the agreement which was entered at the time of minority. So suppose if I say that I had promised, I am a minor, fine. I as a minor, I had promised someone to pay rupees 10,000 when I was minor. Now on becoming major, I cannot sign that particular thing and say that yes, I'm going to pay you 10,000 rupees. So generally what they're telling us, you cannot ratify any agreement that you have entered at the time of minority. But yes, at the same time, in the last point I've stated, a fresh agreement can be entered into with a fresh consideration and a fresh promise. So you can surely enter into a new agreement with the same person on the same topic, but there should be a proper, fair, valid consideration and a fresh promise. So the crux over here is you cannot ratify the agreement or contract which was entered at the time of minority, but you can enter into a fresh agreement or a contract. I hope I am clear with all the points that I had discussed till now in my previous lecture. So this was the entire content that we had covered in our last lecture. So let's go ahead with the fourth provision. The name of the provision is claim for necessaries. First of all, let's understand what is necessaries. Under this I have written, a minor is liable to pay out of his property for the necessaries. Necessary means basic expenses supplied to him or anyone whom the minor is bound to support. So what they are telling in this particular point, that minor is having the liability to pay. Pay out of what? Pay out of his own property. For what expenses? For the necessaries. You can say basic food, clothing, education, etc., which were necessary for the survival. If someone has paid for these necessaries, then minor is liable to pay them back out of his property. Fine. So this is your first point. Further, it is written, anyone whom the minor is bound to support. So I can say if the minor is having a younger sister, fine. Now some person has looked after her younger sister also. So minor will be liable out of his property to reimburse that particular liability also. Because actually it was the duty of the minor to look after the younger sister. But since someone else has taken care of her sister, he is liable to pay out of his property to pay for the necessaries. In short, generally we say minor is not having any kind of liability, but yes, he is having liability with respect to necessaries out of his property. That is, if any basic things were being supplied to him which was necessary for his survival, he is liable to repay the same out of his own property. Second point I had mentioned is the term necessaries is not confined to goods. So it is not only limited to goods, it can include other things like teaching, medical facilities, legal advices, etc. So necessaries, you can say anything which was being necessary at that particular point of time for the survival of the minor or for value addition for the minor. That is teaching, giving him medical facilities, or giving some legal advice for entering into a contract or anything else. All these terms are going to be classified under the head of necessaries. And the last point is only the property of minor is liable. The minor is not personally responsible to pay for the necessaries. This is again the most important line to remember, friends. What I've written over here, only the property of the minor is going to be liable. That is, if minor is having any kind of property, he is the owner of something, he need to pay out of it. But however, if he is not having any kind of property, then he is not going to be held personally responsible to pay for the necessaries. So for example, I am having no assets in my name, then I am not personally liable to make good for this necessaries. Only if I am having any property, then I am liable to pay out of my property. I hope I'm clear with this particular point. Just giving you a moment, take a view at all the 3 points which are mentioned over here. Well, I hope you are clear with this particular slide. Okay, let's move ahead to the next point. No estoppel. First of all, let's understand what is the meaning of the word estoppel, under which I have written estoppel means a man who, by his words or conduct, induced others to believe in the existence of certain fact, knowing that they might act on this behalf. So basically, what they are trying to say over here is any person who, by his words or conduct, that is either he's explicitly telling something or he's doing something which is making other person to believe what basically they are going to believe over here, that anything is being in existence, that there is some fact which is true, which may not be, which may be fine, and he knows that on that particular basis the third party is going to do some action, is going to take some action. Now let's take an example. For example, you all know the Taj Mahal which is situated at Agra. Now suppose if NRI comes, please understand this is just an example, fine. So what I'm going to say is, suppose if any NRI comes to visit Agra, I am the person who is basically giving all the instructions about that heritage. Now I, by my actions or by my words, make him believe that Taj Mahal belongs to me, it is my own personal property. Then in this particular case, I am the person who will be termed as an estoppel, because actually this is not my particular property, fine. But still, by my actions or by my words or by any of the documents which may be fake, I am making the third person believe that this is my property, and the third person is going to offer me to purchase that particular monument. So basically, I know by doing this thing, there can be any action which may be coming from the third party. So if this is the case, who am I? I will be considered as an estoppel. I hope I'm clear with this particular meaning of the word estoppel. Now in the second point, I have related it with the minor. A minor falsely representing himself of the age has induced a person to enter into a contract with him can nevertheless plead minority as a defense in an action of agreement. What they're trying to say over here is, minor is someone who is below the age of 18 years generally, and we know that in India an agreement with minor is void ab initio. But somehow minor, by his actions or by his conduct, make the third party believe that he is major, he is of the age of more than 18 years, and he is actually competent to enter into a contract. What is the actual thing? He is below 18 years, he is minor, but by certain words or by certain actions or his conduct, he is making the another party believe that no, he is above 18 years, he is major. Now by this thing, the third party is relying and he is entering into a contract with the minor. In this particular case, who is the estoppel? Minor is the estoppel because he has represented falsely. Now in this particular case also, minor can plead his minority as a defense, which means he can use this particular thing as a defense that he was a minor, so he has a right to cancel the contract. Why? Because any agreement entered with a minor is void ab initio. So just see over here that estoppel is something which may be wrong, which may be right, depending on the situation. Fine. But over here, minor has the power to take the benefit of this particular thing also. So just you need to remember over here that though you have entered into a contract with a minor, believing he was major, still you are not having any kind of power, and that agreement is going to be considered as void ab initio only, because actually he was minor. But in the last point I have stated, contract entered into with the minor is null in the eyes of statute, and there cannot be any estoppel against the statute. So what they've written over here, if you are entering any kind of contract with the minor, it is void ab initio. That is, it is null and void as per the eyes of the law, as per the eyes of the statute, and there can never be any estoppel against the statute. As a result of which, what we are supposed to remember over here, though you have entered into an agreement with the minor, considering him major, who is at fault? You are at fault, because you should have taken due care about his minority. As a result of which, what this entire topic wants us to say is, though minor is acting in such a manner that he is a major and entering into agreement, another part is not going to have a defense that he was estoppel. No, he is not going to bear this particular thing, and minor can use his minority as a defense, saying that actually he is below the age of 18, so any agreement entered with him is void ab initio. I hope I'm clear with this particular topic. Let's move to the next part. Point number 6. No restitution or compensation. First of all, let us understand what is the meaning of restitution or compensation. It basically means to return back the benefit which was received by minor in the contract. So what this topic is going to tell us is, if I had received any benefit in the contract when I was a minor, so do I have any liability to return that benefit what I had already received by entering into a contract? So basically this topic tells about restitution or compensation, that is to return back the benefit that I had received as a minor by entering into an agreement. You know that any agreement entered with a minor is void ab initio, that is null and void, not having any legal existence. But by entering into a contract, if I had received certain benefit from the third party, so whether I am liable to return him back the benefit that I have received just because the contract is void ab initio? Let's look into this. The second point tells a minor cannot be compelled to compensate for any refund, any benefit which he has received under the contract. So primarily, what is the rule? Minor cannot be forced. He cannot be compelled to compensate or refund any benefit he has received. So though my agreement is void ab initio, I was not going to enter in this particular agreement, but still, if I have received anything from the another party, I am under no obligation to return it back as a minor. So I cannot be forced to compensate for the same. However, where the minor induces the opposite party to enter into the contract with him by fraudulent representation of his age. Now this is again a twist in this particular point. That generally he cannot be compelled to refund. But if he has induced the another party by fraudulently representing his age, that he is representing in such a manner that he is above the age of 18 years, then in this particular case, he is under the obligation to return the consideration he had received. So generally, he is having no liability to return back what he has received as the benefit. But if he has done any fraudulent representation of his age, and on believing on this representation, if the opposite party has entered into a contract and passed on the benefits to the minor, then the minor is going to be held liable to return or compensate this particular benefit. I hope I'm clear. I'm just giving you a moment. Take a view at all the 3 points. Well, friends, I hope you are clear with this particular topic also. So let me recall all the 3 points that we had covered today. The first point was claim for necessaries. That if a minor has received anything from some another person for his necessities, that is like his basic food, clothing, shelter, or we can say for his basic educational facilities or medical facilities or any kind of legal advice, he is going to be liable to repay for the same out of his property. However, he is not going to be held personally responsible to pay off the same. So only if he's having any property, will be liable for the same. If he's not having any kind of property, he cannot be held personally liable to repay for the necessaries. Second point is no estoppel, under which I had explained you who is estoppel, who by his act or by his words makes someone else believe which may be right, which may be wrong. Fine. And the third person who has actually believed something, he is going to act on that particular knowledge. If this is the case, that person is going to be termed as estoppel. So if the minor by his way or by his conduct is making someone believe that he is above the age of 18 years and trying to enter that another person into an agreement. However, here it is written in the law, though it is the case, minor will having a clean sheet because any agreement entered with the minor is voided in issue. So it was the responsibility of the person who was entering into a contract to check about the proper age of the minor. So again, minor can claim his minority as a defense in this particular thing. And the third point was no restitution or compensation. That is, if I had entered into an agreement when I was minor, and if any benefits were passed to me under an agreement, though we all know that any agreement which is entered with the minor is void ab initio, which is having no legal existence. So if I had received any benefit, actually I should have returned that, right? But am I liable to return the same? Answer is no. If in general sense, if you have entered into a contract, you cannot be compelled as a minor to compensate for the any benefit you have received under the contract. But however, if you had entered into a contract by fraudulently representing your age to the another party, then yes, you are liable to refund any benefit you have received under that particular contract. I hope I was clear with all the 3 points that I had explained in my today's lecture. So I would like to take a pause over here. We are going to continue from the next point under the same answer in our upcoming lecture. Till then, I, CA Pujan Kapadia, thank you all for your patient listening, and I definitely hope to see you all in my upcoming lecture. Thank you, friends.